Mr. Prabhakar.
Good afternoon.
Slightly, you can tilt the laptop towards yourself. Yeah, now much better. Yeah. Good afternoon, and we welcome you all to have insights on a topic which a common man also tries to understand, because one sometimes buys a property with a bona fide intent. But what are the implications? Let's assume there is some charge created, whether it is barred by limitation. What are the ways forward, and what is the legal journey as such, so that you don't get into the trappings of, as they say, sometimes your intent to buy a property is good, but the trappings of law and the provisions, the ignorance, can lead you into more troubles. Because more so, we have also found that sometimes one buys a property in an auction. We also find as to whether, as is various basis, what would be the impact of that. And even otherwise, buying a property, normally we all say that the land is also destined just like any other things. So, but what are the caveats which one has to take into consideration? And let's assume you have bought a property which has some legal implications, mortgage, etc. What could be the effect if there is no entry? Keeping in view all these facts, we requested Mr. K. Prabhakar, who has already come on our platform and given the insights. And as we all know, that while decimating knowledge, he also dissects the judgments in his own way to state therein that what should be the implication and what is the effect and what is the way forward. And I understand, being a weekend, though during these lockdown times, sometimes you even don't realize that it's a weekend. So without taking much time, Mr. K. Prabhakar, an eminent lawyer from Madurai and Madras, would be giving us the implications of an understanding of the doctrine of Bonafide purchase and what is the way forward and how can we move forward in this way. Over to you, Mr. Prabhakar.
Thank you, Mr. Vikas. I have to be grateful for some of the very good lectures which I could hear through your channel. In fact, it is a treasure trove. As a student of law, we would like to be enlightened by somebody who is the best person in a particular field. In some of the lectures in the past 3 or 4 weeks, I would say with the conviction that I have learned something from the lectures. Thank you. Now coming to the peculiar topic, bona fide purchaser. Who can be called as a bona fide purchaser, and what are the implications? You'll be all known that a purchaser has to verify every register, whether it is a revenue, municipal, or even courts for that matter. And often he will end up in a quicksand. The reason is that even though the system has been perfected more or less in the registering authority throughout this country, the same cannot be said of the judiciary or the courts for that matter. And for all the purposes, from 1873, when this act, Transfer of Property Act came, Section 1052 of the Act, which says that any transaction during the pendency of the suit will be subject to the result of the suit, and it has been held by the courts that this is a public matter of public policy, and therefore whether or not you have got the knowledge about the pendency of the suit or a contract which has ended up in court, and you have landed yourself in purchasing the property, then section 52 will come into play. Then there is absolutely very little option for the purchaser but to go with the vendor, take the chance, and if the vendor succeed, you will succeed, or otherwise you will lose the property as well as the money. The When I took the topic in the second leg, which I like to suggest something as a way forward. Normally, legislation breeds litigation, and so is the judicial decisions. And if you want to reduce the litigation, probably may not be the forum. The forum is for the benefit of the lawyers. So long as these types of provisions are available, it will be a gold mine for the lawyers. But a sad plight for the people, innocent purchasers who landed up with the problem. Therefore, the law which has been enacted with a sufficient safeguard with regard to bona fide purchaser is the topic today. And as Mr. Vikas has suggested, to include the particular reference to section 53 of the Transfer of Property Act, we call about the fraudulent transfer. I would like to brush my friend's memory that bona fide purchaser theory doesn't confine itself to section 53, namely the fraudulent transfer. But also there are some provisions like section 38, 41, 43, 51, 53, 53A, and 100 of the Transfer of Property Act. And then looking ajar, insofar as the civil law is concerned, section 19B of the Specific Relief Act and section 17 of the Limitation Act. In a broad parameters, we can see these sections and find out where all this bona fide purchaser theory comes into play. I'll give you a brief outline about the sections of 38, 41 and 43 before we move on to section 53. In fact, when the notes were circulated, I have specifically did not mention about section 53A because more or less this 53A and the bona fide purchaser has been taken care of by Act 48 of 2001, whereby unless an agreement of sale is registered, the question of getting a shield or protection under section 53A that you are ready and willing to perform your part of the contract and you have done something in pursuance of the contract and you want to protect your possession, which is all about section 53A. The fact that the Central Act came in 48 of 2001, we call it as Mr. Arun Jaitley's law, which he has implemented, and rightly so. This bona fide purchaser under section 53A more or less went out of, it's not in vogue for particular purpose of 53A. The reason is, if you want to get protection under 53A, the document must be registered. But there are maybe still cases where a person, after filing the suit for specific performance, filing a suit under section 53A, still whether you will be a bona fide purchaser will come into operation or not. This bona fide purchaser theory can be taken, can be split into two. One is executed contracts and executory contracts. Executed contract is a sale deed or a settlement or any document. We can't say that in case of a bona fide purchaser, settlement is not for consideration. We'll leave that. But in cases of any document like a sale or an exchange, then it becomes an executed contract. Already it has been done. The second is an executory contract, namely an agreement of sale, where in furtherance of the agreement, something has to be done by the act of parties, or They can even come to the court for filing a suit for specific performance. In such a cases, Section 53A will apply or not, that's one theory. But now coming to some of the sections which speaks about the bona fide purchaser. Section 38 of the Act, Transfer of Property Act, speaks about a bona fide purchaser, but in a very limited sense. Namely, if a person has been authorized under certain circumstances to transfer, and he represents that certain circumstances spoken about to do subsist and transfer the property, and if a person has purchased the property for a consideration, then he will be protected. That is Section 38. See in what cases it will apply. Suppose a power of attorney is given, imposing some conditions. Before ever the power of attorney can act as the agent of the principal and to transfer the property. And when purchaser think that the circumstances which has been spoken to under the power of attorney document or a deed do exist. And if such a representation is made, and if he makes an honest inquiry, and if he purchase the property for a consideration, and subsequently, if it is found that the conditions of this has not been fulfilled, or the circumstances which has been spoken to under the document, in fact, really doesn't exist, then also the purchaser can be protected, provided he is a bona fide purchaser for value. What is a bona fide purchaser for value? He should not know about the background or the facts. He doesn't have the knowledge of this condition or the circumstances which is spoken to in Section 38. And he made some honest inquiry. This bona fide purchaser can be applied or can be claimed by a person who comes to the court in all fairness, and the very cornerstone of this bona fide purchaser is honesty and integrity. If the honesty is not there, fairness is not there, a person who wants to meddle with the affairs or to purchase litigation instead of purchasing peace, then he cannot be called as a bona fide purchaser for that matter. Therefore, Section 38 has got very limited application in a sense that practically we don't have that kind of a situation today, which was there in the later part of the 19th century, that if a person has authorized somebody to execute a document or sell the property or transfer the property, if some circumstances exist, and then if the circumstances exist or not is a question of fact, and if a purchaser makes some inquiry and find that there are some circumstances which do exist, and he honestly believes in that and purchase the property, is protected under Section 38. As I have said that practically we don't have much of cases under Section 38. What about 41? Ostensible order. What is the definition of an ostensible order? A person who professes to be the owner, but he is not the real owner. If somebody is the owner of the property and he makes a representation, no, that I am the owner of the property and sells, then whether he has got that consent, express or implied, to do that. What Section 41 says is, where with the consent, express or implied, a person interested in a movable property is the ostensible owner of such a property, and if he sells the property or transfers the property for a consideration, then a purchaser can be called as a bona fide purchaser. What are the conditions involved? First, the person who transfers the property is not the real owner. Two, the real owner must give a consent, either express or implied, for the transfer of the property. And on the basis of this express or implied consent, a person sells the property. then the purchaser becomes an absolute owner of the property. I will give you a crude example which normally comes to the court. Suppose a property has been purchased in the name of husband and wife. It is out of the Benami Act. The husband wants to sell the property, the wife also consents it. Husband meet the purchaser at his home, wife was also available, and both of them consented for the sale of the property, and the husband, in the presence of the wife, said that there is no need for my wife to sign the document. It is enough for us, for one of us to sign. I will come and sign the document. There is absolutely no issue. I have paid the money. Absolutely no difference of opinion between us. The purchaser believes this representation and got the properties registered in his name for a consideration, namely a sale. Whether this purchaser will be protected under Section 41 of the Transfer of Property Act or not? Certainly. Where, with the consent express or implied of the persons interested in a movable property, a person is the ostensible owner. Because of this consent, the owner becomes an ostensible owner. Normally, it will happen in cases of a very close family relation, or it can even be in case of a co-owners. But if it is in case of a co-owner not related by blood, then the law may demand a bona fide purchaser to come out with something above the beyond the normal circumstances to show that there was an implied or an express consent from the real owner to the ostensible owner. This is Section 41. I like to draw my friends' attention to some of the judgments on that score. One is the first judgment, I think it has been circulated now. Hardev Singh versus Gurmail Singh, 2007 to SEC page 404. Go through this judgment. It is a judgment where the general ingredients of the section has been spoken to, and the ingredients which the Lordship would say are the conditions which have to be satisfied are the transferor, the person who sells the property. One, the conditions are the transferor is the ostensible owner, or two, he is so by a consent implied or expressed. Three, the transferee has acted in good faith. What is the good faith? As I have suggested in the example, a person goes to the home of a vendor where the wife and husband are there. He got the consent, and he then thought that there is no need for the wife to come and execute the document. Therefore, three conditions have to be satisfied for a purchaser to be called as a bona fide purchaser under Section 41. Namely, the transferor is the ostensible owner. Two, by consent express or implied, the ostensible owner is permitted to sell. Three, the transferee in good faith and purchased the property got the transfer for a consideration. Therefore, all the three has to be satisfied. And this judgment of the Honorable Supreme Court speaks about these conditions which are necessary to invoke by a purchaser to call himself as a bona fide purchaser in case of Section 41. The second case is Sankara Halli versus and the Sankara Institute of Physiology and Culture versus Kishori Lal. 1996-7 SEC page 55. 1996-7 SEC page 55. If you go through the Act under Section 41, it speaks about the implied or express consent. And this implied consent has been reiterated by the Honorable Supreme Court in Sankara Halli's case, where the Lordship would say that the consent need not be expressed. But in case of an implied consent, then the circumstances to draw such an inference must exist. So the court can invoke Section 41 to protect the purchaser. Therefore, in case of an express consent, there may not be much of a problem. But in case you take the route of an implied consent, then the bona fide purchaser has to redouble his effect and to prove that the consent is there. The circumstances and the facts surrounding the entire episode denote a logical inference of a consent, which is called implied consent. The point at issue is the bona fide purchaser, the burden is upon the bona fide purchaser to show that he is a bona fide purchaser. Under section 43, there is an additional burden upon him to satisfy that the ostensible owner is really the ostensible owner representing somebody else. Namely, there was an express or implied consent. Unless and until these ingredients are satisfied, the question of invoking section 41 does not arise. The next one is feeding title by estoppel. We don't find this language in section 43 of the Transfer of Property Act, but normally any lawyer would say that section 53 speaks about feeding title by estoppel. What is feeding title by estoppel? Suppose I am not the owner of a property, and if I sells to you by making a representation which is either fraudulent or erroneous, then this transaction has no value on the day, because I am not the owner of the property. I am not the owner, but I make a fraudulent or an erroneous representation that I am the owner and sell the property. And subsequently, I get title to the property. If I get title to the property, and whether the purchaser's right will be protected or not, this is section 43. On the day of the document, I am not the owner. I make a representation, a fraudulent or an erroneous, that I am the owner and sells the property. And subsequently, I became the owner. And if I became the owner, whether the right already transferred on a fraudulent or an erroneous representation will make the transfer valid, of course. But some ingredients have to satisfy. Namely, there should be a fraudulent or an erroneous representation. And the purchaser believed that representation and purchased the property for a consideration, again for a consideration, not for any document which lacks consideration like a gift or a settlement. 43 would say that if a person doesn't have the ownership but makes a fraudulent or erroneous representation, and on a reasonable inquiry, the purchaser finds that that he was the owner and he was misled thoroughly and he purchased the property. Subsequently, if the vendor gets title to the property, that title will feed the purchaser, called feeding title by estoppel. I will give you an example so you can understand what is feeding title by estoppel. Suppose my father is the owner of the property. He is alive. I represent that I am the owner of the property. Properly, I can say that my father is dead and I transfer the property. A representation fraudulent. Assuming for a moment the bona fide purchaser makes some inquiry and in the vicinity the father was not there, nobody was able to tell him that father is alive, then we find that father was alive. Subsequently, he passes away. The vendor who sold the property was the only son. Therefore, on the demise of his father, the property again devolves upon the son by way of inheritance because he died intestate, assuming for a moment. Intestate. Then what will happen to the transfer made by this son to a third party? And the third party was also misled thoroughly in after making some honesty inquiry that whether father was alive or not. He was not in a position to find that he was alive. This is called as feeding title by estoppel. Two ingredients must be satisfied. Either one of them must be satisfied, namely, in such cases, the representation must be fraudulent or erroneous. When it will become fraudulent or erroneous, these two things cannot or go together. It will operate on a different field, but erroneous representation and fraudulent representation are two different things. Erroneous representation is not with an intention to defraud. Probably a person who is on an impression, a mistaken impression, and he makes the representation and transfer the property. Then he is called as it's a erroneous representation. But if a person knew the fact, but suppressed the same, or not revealing the truth and selling the property, making a fraudulent representation, that certain things exist or doesn't exist, then if any one of these two is available, then a purchaser will be protected as a bona fide purchaser. But again, the problem is, if the purchaser, on a due diligence, on a reasonable inquiry, is able to find out the truth, and still he went ahead and purchased the property, can that representation made by the vendor be called as erroneous or fraudulent? It cannot be. Assuming for a moment, a son say that my father is dead, and you know it for certain that father is alive, but son is in possession of the property, he is holding the fort in the property, and you are also aware of the fact that father can never take possession of the property from the son, and you went ahead and purchased the property. Then you cannot be called as a bona fide purchaser because it can neither be called as fraudulent nor erroneous if it is a particular fact is within the domain knowledge of the purchaser. Therefore, in cases if you want to attract section 43, the representation must be fraudulent or erroneous. And if it is not there, the question of the purchaser becoming a bona fide purchaser does not arise at all. My friend, because I cited one auction today, the opening, there is a direct judgment at that point. Jyoti Singh versus Ramdas Nath, AAR 1996 Supreme Court, 2773. Jyoti Singh versus Ramdas Nath, AAR 1996 Supreme Court, 2773. A case where the Supreme Court refused to apply the principles of Section 43 in case of an auction. Why? There is a case of an auction made through a court of law, and somebody wants to take the route of Section 43 that I am a bona fide purchaser for value. The court said that in case of an auction purchaser, the question of attracting Section 43 does not arise. Why? As I said, that the opening words of the section would say, when a person fraudulently or erroneously represents, therefore, when a court sells a property, it doesn't make any representation. You and I are aware that a court sale, there is no warranty of title. whether it is in execution or anything else, there is no warranty of title. It is only following some certain principle that instead of a person who should sell the property, the court takes upon the mantle to transfer the property as though it is being done by the person or the person who is liable to pay the money due under the hearing. Therefore, whenever a court auction comes up, a person cannot say the court made a representation. Obviously, when the court sells the property, it cannot make any representation. The question of making any representation fraudulently or erroneously doesn't arise. But this is clarified by the Supreme Court in 1996 in Jyoti Singh case. Now, summing up this section 43 before moving to section 51. When a person fraudulently or erroneously represents that he is the owner or authorized to transfer certain immovable property and professes to transfer such a property for consideration, such a transfer at the option of the transferee operate on any interest which the transferor may have at any time during the contract. But nothing in this section shall impair the right of the transferees. That is if it is for a consideration. That fraudulent or a bona fide or a erroneous representation is the touchstone of this section. If it is not there, the question of invoking this section does not arise. I can give you a practical example which I came across some time back. If mother was the owner of the property, son sold the property. Subsequently, mother passes away. The purchaser files a suit that he is entitled to the property. Son files a counterclaim for recovery of possession. The purchaser took the stand that I am protected under section 43 because even though the mother was the owner of the property on the day when the property was sold, son becomes the owner on her death because the mother died intestate. Therefore, it will feed my title. But on facts, what has happened was, during the cross-examination, the party was able to establish that the purchaser knew on the day when the property was transferred by the vendor, that vendor was not the owner, mother is alive, and mother is alone the owner of the property. Once this situation comes into existence, then the question of applying 43 doesn't arise because its opening sentence would say that it should be a fraudulent or erroneous representation. If the other man knows the fact, the question of making a fraudulent or an erroneous representation does not arise at all. Now coming to section 51. What is section 51? It's a peculiar section. Not many people apply in a real world. The reason is it is a rat race. We don't go by equity. At the end of the day, we may not be in a position to apply this principle after losing the case. Is it possible to convince any party to come under this section at the time of filing the pleadings or at the time of trial? It's $1 billion question. In my lifetime, I never did that. No client was willing to accept. I'll come there in the section. What is section 51? Section 51 says, if a person has made some improvements on the basis of a defective title and subsequently the original owner sought for possession of the property or for recovery, then in between, if the purchaser on a defective title made some improvements in the property, he can demand the original owner to compensate him for the improvement. What is that compensation for improvement? Section 51 of the Act When the transferee of immovable property makes any improvement on the property believing in good faith that he is absolutely entitled to, and he is subsequently evicted or sought to be evicted by the real owner, the transferee has a right to require the person causing the eviction either to have the value of the improvement estimated and paid or to sell the interest in the property to him. Two options are available for a purchaser. One, it is a case of a purchaser making a wrong choice. Namely, he went ahead and purchased the property from a person who is not the owner, but he honestly believed that the vendor was the owner. But subsequently, the original owner comes along and he sought eviction of the property. Then if eviction is sought, what are the defenses available? As I said, it is an option choice. Can a lawyer at the trial side disown your right under the title deed and ask for an improvement in respect of the superstructure, or demanding the person who is the real owner who comes up for a suit on possession to sell his interest in the property, namely this site? It is a peculiar case of a superstructure constructed by a person who is not the owner, but thinking that he is the owner, and a person who is the absolute owner without possession, allowing somebody else to put up concession. Now I can draw an inference or an analogy with the estoppel. There are some couple of cases, very interesting cases from Madras High Court on that aspect. Suppose a person goes ahead and purchases the property from a non-owner and put up concession. The original owner, thinking that the man who has purchased the property has purchased from the owner, rightful owner, he has no interest in the property, and he encourages this man to put up superstructure. The purchaser put up a huge superstructure in the property, and subsequently the original owner who has encouraged the purchaser to put up construction on the ground that he has purchased under a valid title stumbles upon the fact that he is the owner of the property. He files a suit for recovery of possession and on title, whether he can recover the property or not. This has got a slight deviation from section 51. Section 51 speaks about the person purchasing the property from a person under a defective title. Here is a case of the original owner not knowing that he is the owner, allowed the other man to put up construction in his own property, and then the question of estoppel will come into play. If I remember, I have not cited those judgments, I'll just give those two judgments. AR 1951 Madras and AR 1965 Madras ACC case. In these, both of them are division bench of the Madras High Court, where it has been held that if a person has put up construction in your property and you have either expressly or impliedly encouraged the other man to put up construction, and subsequently you cannot turn around and ask for possession, and in fact in 1965 Madras division bench, it said that you are not even entitled to compensation. But subsequently there are a couple of judgments overlooking that 1965 judgment that it will not apply in case of a suit on title, etc. But the principle has been reiterated by all the high courts, namely that if a person has sit back and allowed the another man to put up construction and they encourage him either expressly or impliedly, then the question of estoppel will come into play. You cannot recover the property or even compensation. But section 51 is a specific provision which you have to take a call. the purchaser has to take a call, namely whether to go ahead and fight the case on the basis of a title which you may think that it is defective, or straight away have to go to the court and say that that my title is maybe defective, and if it is found to be defective, let him pay the compensation for the superstructure, or I am prepared to purchase the property. But this section, I have not come across any judgment where the court say that you can take two inconsistent pleas and to sustain them both throughout the trial. Namely, to justify that you are the owner of the property under a title which the court subsequently found to be not valid, and a case of giving up your title and asking for a compensation in respect of the superstructure, or ready to pay the compensation in respect of the site so that you can purchase the site from the person who touted to be the original owner of the property. But the problem is, it is a case of a choice which the client has to take. The lawyer has to convince the client. In some cases, it will be very difficult to convince the client that having purchased the property and having paid so much of money, you don't have any right over the property, you go for a compensation in respect of the superstructure and get out. Probably he will get out of your office rather than the case. The straight away that judgment, I like to give two judgments on that aspect. Lakshmi Prasad versus Lakshmi Narayan, AR 1928, Allahabad, page 41. AR 1928, Allahabad, page 41. Lakshmi Prasad versus Lakshmi Narayan, wherein the court has reiterated the principle and expanded the principle and said that if you have put up construction or an improvement over a property in which you believe to be the owner, but subsequently it was found that the title is defective, when this defective title will come into play. Suppose I have not purchased the property, but I have started putting up construction in the property, say like a trespasser. Can you take the protection under section 51? No. Section 51 speaks about a transfer. A bona fide transferee or a person who has purchased the property in good faith from a person who has got a defective title alone can speak about or take or invoke section 51. There should be a transfer. The transferee should have been purchased the property in good faith, and subsequently the title is not there or a defective title, then you can go under section 51. Or in cases where you have put up construction in the property thinking that you are the owner or it is an ancestral property of yours, and subsequently the court finds that the other man is owner, the only option available for you is not under section 51, but under the general principle of estoppel and acquiescence and estoppel. That's what I have said that in AR 51 Madras Division Bench and AR 1965 Madras ACC case. The next case on that aspect is Bharatacharyalu versus Alivelu Manga Tayaru. That is a case from Andhra Pradesh High Court. AR 1996, Andhra Pradesh, page 238. 1996, Andhra Pradesh, page 238. This judgment is very peculiar in the sense, as I have suggested, there are two courses open. One is a person should have been a transferee under this section to invoke section 51. And if it is not so, he can fit his case only under the theory of estoppel under section 115 and acquiescence, a common law remedy. For a common law remedy, there is no need for a transfer. But under section 51, if you want to invoke this provision, then you must be a bona fide purchaser for value. First, you have to establish. But this judgment of the Andhra Pradesh High Court made some deviation. Namely, it is a hybrid judgment. It took into account section 51 It took into account the theory of estoppel and acquiescence. And both of them have been clubbed together. And the court said that there is no need for a person to be a transferee to invoke the rights under section 51. It goes against the section itself. The reason is, the opening sentence of section 51 said, when the transferee of immovable property makes any improvement, it underlies the fact that there should be a transfer and there should be a transferee for a bona fide value for consideration and in good faith. These two conditions have to be satisfied. But this 1996 judgment would say, probably it was more inclined to invoke the common law principle of estoppel and applying it with the section 51 and saying that already you have put up construction, give the compensation. It's more of an equity court under English law rather than a pure judgment on the section 51 of the Transfer of Property Act. Now coming to section 53. What is section 53 and what is a fraudulent transfer? This section is very peculiar in a sense. It speaks about the executed contract and not an executory contract like under section 19 of the Specific Relief Act. It speaks about an executed contract, but it has got a limited role to play. Namely, the opening sentence of the section would say, the intention is to defeat or delay the creditors. Every transfer of an immovable property made with an intent to defeat or delay the creditors of the transfer shall be voidable at the option of any creditor so defeated or delayed. Therefore, this section will come into play only in cases where there are creditors in respect of the vendor. Vendor is a borrower and there are subsisting loan available against him or is liable to pay. And in such cases, he transfers the property. If it is with the intent to delay or defeat the creditor, then that sale can be challenged by the creditor on the ground that it is fraudulent. But there are exceptions to it. The exception again is a bona fide purchaser. You may be aware that a borrower need not be reflected in the registration of documents. If it is only on the basis of a promissory note or any other negotiable instrument, then it will not be reflected in the registry. If it is case of a mortgage, then all right. But in cases where a promissory note or any other negotiable instrument, and the person wants to defeat the creditor, and if he sells the property, then the sale is voidable at the option of the transfer, the creditors. The point is, between the seller or the vendor and the purchaser, there is no issue at all. But it is a case of a third party coming into play and say this sale is tainted by the reason of the fact that there is a subsisting loan available and this man tried to sell the property in order to delay or defeat. Two words are important. Even delay, namely, if I take the property out of the bounds of the creditors so that it will take some more time for them to realize there is a delay of 3 years, 5 years, etc., then also this can be challenged under section 53. It is not as though to defeat the creditors alone. It speaks about two ingredients, delay as well as defeat the creditors. But a bona fide purchaser in the circumstances again will be protected. But there are two things which you have to bear in mind before ever this section can be applied and how it can be applied. I'll run through these 4 judgments on the aspect before going into how this will affect how we have to move forward under this section. First is a judgment which there are a lot of judgments, but I like to draw 4 judgments on the aspect. One is Abdul Sukur versus Arijit Apparao, AR 1963 Supreme Court 1150, and then Dr. Govindas versus Shantabai, AR 1972 Supreme Court 1520, Zorar Singh versus Sarwan Singh, AR 2002 Supreme Court 1711. These 3 judgments can be clubbed together, and a distinction can be made on the 4th, namely Sukhinder Singh versus Jairup Singh, a very latest judgment of the Supreme Court, reported in 2022 Law Weekly, page 796. What is the distinction? It speaks about a bona fide purchaser and what is the role of a bona fide purchaser to prove that he is a bona fide purchaser. The point is, burden is upon the purchaser to show that he is a bona fide purchaser. But you are also well aware of the fact that the burden of proof will pale into insignificance the moment both the parties have let in evidence. That is the common law principle, that both the parties join together, join the trial, let in evidence, and then you can't say that the burden is upon the other party, therefore he has not proved it. The court is entitled to draw inference from the materials available on record. The burden of proof will come into play only in cases where the other party has not let in evidence strictly on that aspect. If the party joins issue and let in evidence on that aspect, then the court is entitled to weigh the evidence and to find out which one is correct. In case of a bona fide purchaser, what are the ingredients which normally the court will look upon to find that he is an innocent purchaser or a bona fide purchaser or a honest purchaser? One is, he should have made honest inquiries in the vicinity. Then he should have gone to this registering authority to find out who is the owner of the property. 3, you should have checked who is in possession of the property. 4, if somebody is in possession of the property, what is the character of possession of the person holding the property? In fact, in one judgment, if I remember, that's also in AR 1951 Madras, the court went ahead and said that it is not enough to find out somebody is in possession of the property. To be a bona fide purchaser, if you feel that somebody is in possession of the property, go and make the inquiry. What is the character of his possession? Whether it's a tenant or a mortgagee or as a owner or a trespasser, you should make an inquiry to come within the 4 walls of a bona fide purchaser. Then what will be the circumstances to defeat the bona fide purchaser? He should be in good faith. It should be in good faith for a consideration. Consideration document can speak. Insofar as good faith is concerned, as I said that the 4 instances are the 4 Indian 1, 2, 3, 4. Go and inquire, make an inquiry in the vicinity or the neighborhood. 2, registering authority. 3, if somebody is in possession, who is in possession. 4, under what authority is in possession, and what is the character of his possession, lessee, licensee, mortgagee, etc. These are, if you have done that, you will satisfy all these grounds. Now, to defeat this, somebody says that he is not a bona fide purchaser. He can never be called as a bona fide purchaser. And what are the circumstances which the court will look into? Say, for example, the property has been sold for a song. Namely, assuming for a moment a property is worth 1 crore the sale reflects only 10 lakhs, then grossly undervalued. I'd say that not in all cases we can challenge the sale deed, because there is a doctrine famously or infamously called as doctrine of lucky purchase. Suppose a person in distress sells the property for a song, and if you are able to purchase the property, what is wrong in it? Under the English law, we say it's called as a peppercorn theory. What is a peppercorn theory? The consideration can be cash or kind. This kind can be even a pepper or a corn. There should be some consideration, that's all. But in cases of a specific performance of an agreement of sale, the court will go into the nitty-gritty, what is the value of the agreement. The reason is it is not an executed contract. In cases of an executory contract, the court will go into. But in case of an executed contract, if you want to set aside by the seller on the ground that the property was purchased for a song, the court will not accept. But in cases where this theory comes into play is a person calls himself a bona fide purchaser. Then you are not a bona fide purchaser for value. A creditor comes and says, because this property is worth 1 crore, you have purchased it for 10 lakhs. Why this plays an important role is this. If a person sells the property for a far lower value, then a duty is cast upon the purchaser to find out why this property is being sold for such a grossly lower value. If you have not done that, then you don't have any good faith to purchase the property. Second, the circumstances. What will be the circumstances? Neighborhood, whether you have examined, whether you have gone and inquired. Then, if the sale is made, which is being challenged as fraudulent by the creditor, to a near relative or to a neighbor, these are the circumstances which the Lordship would say in 1963 Supreme Court that even though the burden is upon the purchaser and this burden is light, if the circumstances shows that the purchaser is not all above board, then the court can say that he is not a bona fide purchaser. These 3 or 4 things which I have mentioned has been listed by the Honorable Supreme Court as some of the instances which it has discussed, in fact, one by one. I think the 1963 Supreme Court, page 1150, is an authority on that point. But sadly, there was a very recent judgment of His Lordship, Bona and Bonavadi, reported in 2022 Law Weekly, page 796, Sukhwinder Singh versus Jairoop Singh. In that case, 1963 Supreme Court or 72 Supreme Court was not brought to the notice of the court. But it was a case where somebody said that you are not a bona fide purchaser because it is a small village and every villager knows the fact. And in fact, the trial court found that he cannot be a bona fide purchaser because it is a small village, everyone in the village knows the fact. It directly comes into conflict with the AR 1963 Supreme Court, in my opinion. The reason is, the court has said that you cannot brush aside or paint a purchaser as not a bona fide purchaser, but a malafide purchaser, merely because on an assumption that the entire village will know that. But one of the ingredients which went into the decision in the AR 1963 Supreme Court 1150 is that if it is in the neighborhood or in the village, if a purchaser is from the very same village, then he should know. He can't feign ignorance. But the latest judgment of the Supreme Court says that a villager need not know about the fact, even though it is in the hails from the very same village. How to distinguish between these 2 judgments? If you think aloud, one can very well say that those are the days when any news in a neighborhood, in a news in a house, or a secret in the house is a news of the village. A secret in the house is a news of the village in those times. But now in the fast-paced world, probably we don't know who is in the neighborhood. We are not even aware of our neighbors. We are not in talking terms. We are on the run. Therefore, the judgment of the Lordship Bopana and Bonamadi can be justified on the ground that in the present day circumstances, we cannot impute knowledge to a person simply because he belongs to the purchaser belongs to the very same village where there is a problem with regard to the debtor and creditor. But even now, apart from cities, one can very well say if somebody is in tremendous pressure of debt, then will not be a knowledge to the persons in the neighborhood. But this is a fact which has to be established in the particular case. There can't be any hard and fast rule. And coming to the suit by creditors. If a person says that he is a bona fide purchaser, the creditor under this section has the option to file a suit to challenge the same because it is only voidable and it is not void. At the option of the creditor, any alienation made to defeat or delay the creditors is voidable at the option of the creditor. Therefore, the creditor has to make a move. How he has to do it? Whether he has to file a separate suit challenging the alienation, or if the creditor files a suit for recovery of money and he brings up this property for sale, and somebody comes forward and says that he is a bona fide purchaser for value, then whether in the execution proceeding itself a person can say that he is this is a fraudulent transfer, ignore the transfer, bring the property for sale. The two options available are this. Suppose a creditor feels that in order to defeat my claim, the property has been transferred and the transferee is not a bona fide purchaser for value, then the creditor has to file a suit on the ground that the vendor is liable to pay money, and if he has already filed a suit and did not secure any attachment of the property, still whether he can at the time of executing the money degree bring this property for sale alleging that the transfer is a fraudulent transfer, or necessarily the creditor has to file a separate suit for setting aside the sale. This has been quite nicely, this has been settled by a judgment of the 5 judges of the Madras High Court in Ramasamy Chettiar versus Mallappa Chettiar, 1920, Madras Law Journal, page 350. 1920, Madras Law Journal, page 350. In the judgment, it has been held. In fact, there are 4 judgments available, different judgments, but concurring judgment. After analyzing all the legal position, the court has said, creditor has got 2 options. If he wants to challenge the sale deed, he can very well file a suit for a declaration that the sale deed is fraudulent and is null and void. Or he can, after getting a degree in respect of his money claim, lay an execution application against the property. And if somebody comes and says that he is a bona fide purchaser for value, then that can be decided in the execution application itself, either under 47 or 2158 or 2164, whatever the method which you have got under the execution proceedings. Therefore, both the options are available. The next question is, we are now on to the reversal, namely, we are not now trying to protect the bona fide purchaser, but to protect somebody against the onslaught of a purchaser who is not a bona fide purchaser but a mala fide purchaser. This section speaks about creditors. Whether a suit has to be filed by a single creditor or by all the creditors. there is this question. In case of, if you say that the transfer is a fraudulent transfer, you want to challenge the transfer, then whether it can be done or not and how it has to be done. I am only one of the creditor. I don't know who are the creditors. How to file a suit? Just like a suit under Order 1, Rule 8, a representative suit. A suit by invoking Section 53 must be filed as a suit in a representative capacity for and on behalf of all the creditors. It cannot be filed by a single creditor to benefit himself alone unless there are no other creditors. Even then, what he has to do, if all the creditors are not available or not coming with him to file a suit, or he doesn't know anybody who has also lent money like him, what he has to do is he has to file a suit on a representative capacity and then take the procedure under law to inform everybody who wants to join the suit to make this alienation as null and void, as fraudulent. That provision is available. But the point is, a single creditor cannot file a suit for himself alone as a single creditor. He can file a suit without impeding other creditors if he doesn't have a knowledge. But in all cases, whether there are multiple creditors or not, you have to file a suit only in a representative capacity, so that if some third party is there whose interests are also affected, they can come and join the suit either as a plaintiff or as a defendant. And then coming to the last aspect of Section 19, the bona fide purchaser without knowing the contract. These two judgments, Muhammad Ubayatullah versus Haji Abdul Wahab, AIR 2001 Supreme Court, page 1658, and Lakshmi Ammal versus Lakshmi Ammal, AIR 1991, Madras, page 137. I'd like to go run up. I will give you a run up to this judgment. The settled position was at one point of time, what is the burden on a bona fide purchaser? How he can say that he is a bona fide purchaser? He has to prove the negative. Namely, he went ahead and made some inquiries, honest inquiries, encumbrance, registering authority, neighborhood, etc., etc. These are all fact which is to be stated only in oath, except the encumbrance where you can obtain an encumbrance certificate. In all other cases, it is only a statement on oath. Therefore, in one judgment of AIR 1991 Madras, page 137, the court has said that the burden on the purchaser is very light. Namely, he has to just get into the box and say or feign ignorant that he made honest inquiry and has purchased. Then the burden is over or discharged. That is the judgment of the Madras High Court. But the judgments of the Supreme Court, especially in 2022 Law Weekly, is simply brush aside that thing. In fact, it has been argued in that case by the Supreme Court that the burden is light upon the purchaser and it has been discharged. The court said that it is not so. The burden is not light. Or if there are facts and circumstances which speaks otherwise, merely because the purchaser has gone into the box and said that I am the bona fide purchaser, I have made some honest inquiry, that is not enough. That is not enough. Coming to Section 17 of the Limitation Act. This one provision which has not been used by the lawyers in the trial courts, I would say. The reason is this, this provision would protect the bona fide purchasers. How it will protect the bona fide purchasers? A suit can be filed if a person finds that it was a transfer is a fraudulent transfer or a mistake, etc. And a 1 year period is given from the date of the knowledge. If you go through Section 17 of the Limitation Act, a suit can be filed from the 1 year within on the date of the knowledge, etc. Therefore, an allegation can be made that I know very recently and I am coming forward. But suppose a purchaser comes into picture, namely, you want to impugn a particular transaction as a fraudulent transfer without knowing any fraudulent activity in the document. Another document comes into play. Suppose A sells the property to B, a fraudulent transfer. B subsequently transfers the property to C. After this transfer, whether A can file a suit challenging that it was a fraudulent transfer. The law says that in such cases, if another transaction by way of a registered document comes into play, then you cannot brush aside the first document, or you cannot set aside the first document unless and until you are able to establish that the second document or the purchaser under the second document knew about the fraudulent transfer. Normally, in case of a purchaser, the burden is upon the purchaser to show that he is a bona fide purchaser. But in case there is a second transfer, and you say that the first transfer is not a bona fide transfer, but a fraudulent transfer, and you want to challenge both, then the burden is upon the person who challenges the document to impute knowledge. The burden goes to the other party under section 17 if there is a subsequent transfer also. Now coming the way forward. What is the way forward? I'll give some suggestion. Probably none of the suggestion will help a lawyer. Rather, it will reduce the litigation. How it can be done? Why this problem of bona fide purchaser comes into play? In many cases, like under section 19 of the Specific Relief Act, or with regard to this creditors under section 53, we find that we don't have any knowledge about the loan. We don't have any knowledge about the suit pending under section 52. List pendants will come into play. If you want to prevent all these things, like a sub-registration authority or a registering authority, the court should also be transparent. At the stroke of a button, I should be able to find out, is there any suit or litigation pending in respect of a particular property in a village? I do concede we are the capital of software. There is a possibility it can be done. It's a question of how it has to be done. Now I am coming out with a suggestion for some discussion. And I would like to take my friend Vikas here to take this suggestion forward, to bring it to the knowledge of some senior counsels also, whether it is possible to do it. I do concede that in case of a multiple jurisdiction, like a partition suit, some of the properties will be here, some of the properties will be another court. You have to find out. We may not be possible. But many of the cases, if you are able to find out from the court that the litigation is pending in respect of this property, or litigation is all over in respect of the property at the stroke of a button, like an encumbrance certificate, link the court with the sub-registrar office, link the court with the revenue authority, so that if a case is pending, let the purchaser take a call. If the purchaser thereafter take a call, he cannot be called as a bona fide purchaser. He purchased the property with the full eyes open. Then it is for him to defend. But many of the cases, the theory of bona fide purchaser can be reduced in such a way that once this software comes into play, many of the cases will go. Unnecessary litigation will come to an end. Second point is, under section 53, we have said that to delay or defeat the creditors. Now, in one way, section 53A takes out the unregistered agreement of sale by Act 48 of 2001. Therefore, if you want to take protection under 53A, it should be by way of a registered document. In cases of 41, 43, 38, these are all registered documents. But in a peculiar circumstances, you and I knew that those cases are coming down drastically. The reason is that the revenue authority has been tightened, sub-registering authority has been tightened. Now you can't sell the property unless the Qatar Pata revenue record is in your name, or you show something to the registering authority, you cannot sell. Therefore, many of the cases under section 41 and 38, 41 and 43 have gone out. The only thing available is section 53 and another one is under section 19 of the Specific Relief Act. These can be reduced. How? Assuming for a moment, if a promissory note for a certain value or above the value has also to be registered, is it possible? Just we will, I have to think aloud, then how to get a encumbrance in respect of a particular promissory note, whether it is possible. It's a food for thought. My point is, this can be done in such a way that even in case of a negotiable instrument above a certain value, it should be registered. Second, as the power of attorney has been made compulsory, the section 49 has also to be amended in such a way of the Registration Act, where there is a loophole even now, that an agreement of sale can be enforced by way of a suit for specific performance. In many states, this agreement of sale is now made mandatorily to be registered. But an unregistered agreement of sale can be used in a suit for specific performance as an evidence of a contract. That has to be curbed. How it can be curbed? Delete that particular line under section 49C, that in case of an evidence of a contract, remove that line. You make compulsory that if you want to file a suit for specific performance, there should be an agreement of sale must be registered. Then you take all the cases out of the bona fide purchaser. And two, have a system in place in court, putting every property, transparency is the issue, so that a common man know in respect of a particular property there is a dispute, and he can take the call. And in cases where you have a multiple jurisdiction, in case of a partition, you and I know that if a family is in respect of a partition has got some property, it can trace his title to some other document, so that they can even go after some other district to find out. My point is that when each district courts have been under the e-court service, it has come, adding one other method to find out the litigations in respect of a particular property, it will be most beneficial, and the theory of applying the bona fide purchaser will vanish, probably if not now, at least by 2035 or 2040. Thank you, Mr. Lucas, for giving me an audience here.
The audience, in fact, enjoyed it. I can say that. And the suggestions you have rightly said, taking a step forward. In fact, I have also one case. In that particular case, the property stands mortgaged with the bank, and fortuitously, I am representing administration also. In that particular case, he says they enter into a contract with the between two brothers. They say that there is a settlement in terms of that registration was not required. In a regular second appeal, they say that the parties have compromised in view of a mediation, and they get a decree. They move to the administration, stating therein that the property should be transferred in their name on the basis of the settlement. They have not arrayed the bank as a party. Fortuitously, since I was representing the administration as well as the bank in another case, we realized that it's the same case. Now we moved an application stating therein that this property stands mortgage and it was to be sold off in an auction. So now let's see how things shape up. But you are right. Once if there was a litigation and there can be a link, it need not be a party. It's just like a tribunal. An actual copy may not be served. That's what the Supreme Court says. But you can be arrayed so that you are aware of the fact. It is just like in case of mortgage, that you get an acknowledgement in the same way. So the point which you have hammered, I'm just saying that, in fact, I'm party in one particular case wherein this situation has arisen, wherein the property stands mortgaged, but to frustrate the rights of the creditor, they have come out with a settlement stating therein that it was an oral settlement, and so registration was not required. Therefore, the decree has been issued. Now, in terms of the court decree, they are saying that it should be transferred in their name. As to whether what will be the effect, that is to be now settled across. Yeah, this is by Ganesh Tiwari. How doctrine of notice attracts doctrine of bona fide purchaser? Is it audible? How doctrine of notice attracts doctrine of bona fide purchaser? That is by Ganesh.
Yeah. Exactly.
No, his question is how that doctrine of notice will be attracted in doctrine of bona fide purchaser.
Doctrine of notice.
Yeah,
the notice which we speaks about under the earlier part of the Transfer of Property Act, it is only in favor of a purchaser. He will be bound by the notice. If a third party challenges, that theory will not apply. Notice will not apply. Registration is a notice. To whom it is a notice? For the purchaser who says that he is a bona fide purchaser, then the registration will be a notice. The problem is, in court cases, we don't have any notice at all. In case of a registered document, right, all right. Registration is a notice in respect of a person who purchased the property. I tell you one thing, if you go through the section 3 of the Transfer of Property Act, it says that it is only applicable to a transferee. The reason is this. Suppose I am also one of the co-owner of the property and keeps quiet. Somebody sells the property. Then the registration is not a notice to me. Because the law doesn't compel me to go and check the registration every 6 months or every 1 year. This registration will be a notice under section 3 of the Transfer of Property Act only for the transferee and not for a stranger. Stranger, if you say that his rights are affected, he can very well challenge.
Another question is, property held by a person standing in a fiduciary capacity took a bona fide loan / a financial arrangement. How does it work?
Yeah, fiduciary capacity, it goes under the Trust Act section 88. And if there is an exception in the Benami Prohibition Act, then it can be applied. That's all. But the fiduciary capacity, as such, has to be covered within the 4 walls of section 88, and the question of transfer of property doesn't arise at all. It is to be dealt with only under section 88 of the Act, Indian Trust Act.
This is by Prasada. Can an attorney holder representing the principal owner transfer the property to himself in his individual capacity?
I didn't follow, sir. I didn't follow.
Can an attorney holder representing the principal owner transfer the property to himself in his individual capacity?
Yeah, it can be done. Law permits that. Because he has got a dual role, one as an agent. I think if I remember correctly, there is a direct judgment of the Supreme Court that a agent can transfer the property to himself because the 2 roles are different. There is a direct judgment of the Supreme Court.
This is by PCS Rao. If only a creditor files a suit without adding the other creditors, what is the fate of the case filed by the creditor?
The answer is AIR 1955 Madras page 665, and then another is AIR 1968 Punjab and Haryana page 479. Both say that the suit has to be dismissed on technicality. It's not maintainable at all. Either you have to all the creditors or file a suit under Order 1 Rule 8 on behalf of every creditor.
Yeah. I'm just checking it out as to whether there is any question on the this thing. Facebook. there are only praises about a good session on the Facebook. And before we part for the day, the tomorrow's webinar being a weekend, tomorrow join us on the arbitration procedures, the new horizons, the masterclass, since it is in two parts. First would be by Justice Roshan Dalvi, and the another part would be the judgments, etc., by Justice Ramesh from the Bombay High Court. So do connect with us tomorrow at 5 p.m. Thank you, everyone. Stay safe. And on behalf of all the participants, as usual, Mr. Prabhakar was spot on. And the way he took us across, I saw that he took us to the constitutional judgment of five judges of 1920, and straight away to Justice Bhanumati's judgment of 2020. So we have covered a century in that. 100 years of the judicial journey, the way forward. That's the way a lawyer is to be. As I say that as a good lawyer, one has to go through length and breadth and, in fact, dive deep into the law. And that, in fact, shows that 100 years of journey while giving us the insights. We are so delighted that you took us across the wide spectrum of the judicial perspective, TPA, Land Acquisition, Limitation Act, as well as Specific Relief Act. Thank you, everyone. Stay safe, stay blessed, enjoy the weekend. Jai Hind. Namaskar.